You can begin, no? You can begin. Yes, ready? Parties ready? Yes. Okay, call out the case.
Greetings to the Honorable Bench. We are here on the behalf of Rudra Heritage Foundation versus Swargush Digital and others.
Could you just, mic, could you just cover it up? Yes.
Indeed, Your Lordship. The counsel on behalf of the petitioners seeks permission to address the bench collectively as Your Lordships. Much obliged. I shall be taking 22 minutes of the court's time and my learned co-counsel will be taking 21 minutes of the court's time, reserving 5 minutes for rebuttals. Would the counsel request to establish the jurisdiction of the court?
No, jurisdiction I don't think, because you have got sufficient aspect to touch upon. Yes, you can proceed. Yes.
Much obliged, Your Lordship. Would Your Lordships require a brief introduction of the essential facts of the case before proceeding to the...
Very concisely, just to
Indeed,
ensure that you are aware of the facts. Yes.
Indeed, Your Lordship. May it please the court, Pandit Rudra, a renowned classical artist, assigned rights in his recordings in 1985 to Magna Sound, which now vests with Swargush Digital after the 2010 acquisition. Using these recordings, the respondents developed Project Awaz, generating AI outputs, replicating his voice, releasing Rudra Reborn under his persona, leading to widespread public confusion, a viral deepfake, and reputational and economic harm to the Rudra Heritage Foundation. The present dispute arises from this AI-enabled use of identity beyond the original assignment. Is there any confusion, Your Lordship?
Slightly this side, I think there's echoing, I think. You just, okay, now we can do.
Much obliged, Your Lordship.
Yes.
Your Lordship, the Council will be addressing Issue 1, clubbed with Issue 5, followed by Issue 2. My learned co-counsel will be dealing with Issues 3 and 4 subsequently.
So you'll be arguing on issue number 1 and 5?
Indeed, Your Lordship.
And you are clubbing it?
Indeed, Your Lordship. The Moot clarifications permitted the issues to be clubbed together.
You're clubbing 2 and 5?
Your Lordship, 1 and 5 together. Followed by Issue 2.
Yes.
Much obliged, Your Lordship. Your Lordship, the arguments for Issue 1 and 5 shall be addressed in a threefold manner. Your Lordship, the respondents rely on the interpretation of Clause 14b to justify the use of Pandit Rudra's recordings to train AI systems, generating new outputs, replicating his voice and identity. The first submission shall demonstrate that Clause 14b does not extend to generative AI as a matter of contractual interpretation. In the copyright assignment between Rudra and Swargush, the phrase now known or hereafter device in Clause 14b is inherently ambiguous in scope. It is to be noted, under Section 19, Clause 2 of the Copyright Act, assignments must be specific and determinate. The Honorable Court, in the case of Nabha Power Limited versus PS TCL, held that contracts must reflect what parties actually contemplated at the time of execution. The 1985 agreement was made in the playback era, where exploitation meant mere playback formats. Even the concept of generative AI was never within the parties' contemplation.
So your argument is that this clause 14b
Indeed.
did not envisage or contemplate generative artificial creation of this product.
Your Lordship, it is submitted that the recording agreement was signed in 1985, where the very use of generative AI could not have been reasonably foreseen by Mr. Pandit Rudra or any other party.
Is it?
Proceed with their argument.
See, you read that clause. I think when the clause is very clear, unambiguous, does not give room for any interpretation, I don't think we have to strain so much. What it contemplates is, by this clause, Pandit Rudra has assigned all his rights all his rights without reservations, without restrictions. And even he has gone to the extent of stating that you can exploit it by any means. Is it not? So that means nothing is left to him. Is it not? What is the significance of assignment? What do you mean by assignment? It is an assignment of his right.
Your Lordship.
Yes. And under a written document, unreserved, complete right has been given. Has he restricted anything with him?
Indeed, Your Lordship. This shall be demonstrated in the second limb of my submission. If Your Lordships permit, may I start with the very limb itself?
Very?
Limb of the argument itself.
Yes, you can.
Indeed, Your Lordships. Your Lordships, despite the contractual assignment between Pandit Rudra and Swargunj Digital, moral rights can still be claimed under the principles of Copyright Act. Your Lordships, as the Honourable Judge indeed stated that within a contractual assignment, the rights indeed vest onto Swargunj Digital. These rights are vested in 18 Clause 2 of the Copyright Act, and they grant ownership rights, that is also economic rights, to the Swargunj Digital. However, Your Lordships, Section 57 of the Indian Copyright Act retains moral rights within the very individual. These moral rights cannot be alienated from the author itself. These moral rights ensure that the author's identity or the work that the author has created is not distorted or used prejudicial to his reputation. In the present case, however, Mr. Pandit Rudra sadly demised. And however, Section 57, Clause 2 of the Copyright Act retains such rights in the legal representatives of the author. Here, legal representatives of Mr. Pandit Rudra is the Rudra Heritage Foundation. Hence, these moral rights rest rightly within the hands of Rudra Heritage Foundation.
One clarification on that. Is your argument that copyright is assigned and only moral right remains?
Indeed, Your Lordship.
Now, what is the scope of what you can do with a moral right? Isn't it you can only get attribution for your name being associated with the work, or can you sue and commercially exploit a moral right also?
Your Lordship, moral rights protect the very integrity of the work that the author has created throughout his lifetime. They ensure the works does not get distorted. Section 57 of the Copyright Act, read with Section 38B of the Copyright Act, grants performers the right to restrain against any distortions that is prejudicial to their reputation. The here Rudra Heritage Foundation can indeed seek injunction orders to restrain the unauthoritative and illegitimate use by Swargunj Digital. Your Lordship.
Counsel, 1 second. Let's take a step back. Clause 14B of the contract does contemplate remixing as one of the rights available
Indeed, Your
to
Lordship.
the producer. In claiming the moral rights, as my brother judge has just mentioned, in claiming the moral rights, what are you seeking relief against? Is it remixing or is it against representation?
Your Lordships, I would like to have another argument presented in this very matter. The entire clause 14b, should not be read in multiple sets of isolations, but be read holistically. A very holistic part of the entire clause entails the use of mechanical, electronical, digital or other technologies. Here, other technologies is being interpreted as the use of generative AI by Swargunj Digital. The council, using the age-old doctrine of agisdem generis, would like to further elaborate it with an analogy. Your Lordships, for example, if there's a statute that refers to a bus, car or truck, the genus is road transport. Your Lordships, by the very doctrine of agisdem generis, other vehicles would mean other such road transports, not a ship or a space rocket. These would belong to a different set of...
Counsel, I apologize, but that's not my question. My question was, where remixing is contemplated in the clause, what are the moral rights that you are seeking under Section 57?
Your Lordship, there are no particular moral rights assigned. It's just that the author can restrain the use of unauthoritative and illegitimate ways that wherein the work is being distorted.
What are you referring to as unauthoritative and illegitimate ways of distortion?
Your Lordship, the very use of generative AI by the respondents.
That is the right under unauthoritative and illegitimate.
Indeed, Your Lordship, because there was no consensus ad idem on the use of artificial intelligence while signing the contract. The very use of artificial intelligence could not have been foreseen by Mr. Pandit Rudra or Swargunj Heritage Fund, Swargunj Digital Limited. Rights have been granted to technologies that could have only been foreseen at
Aligned.
that very present time.
Please continue.
Much obliged, Your Lordship.
Counsel, actually the statement reads that through mechanical, electronic, digital or other technologies
Indeed.
now known or hereafter devised. So it's also talking about future technologies and not just the technologies that are currently available at that time. So
Indeed, Your Lordship. Your Lordship, now known or hereafter devised should not be read in isolation. It must be understood in light of what was contemplated in 1985. In 1985, it was a mere playback era where exploitation meant mere playback formats and the technologies merely involved cassettes, VHRs, CDs, cassettes, etc. Not the magnitude of what an artificial intelligence system could do. The rights should not breach onto technologies that neither of the parties could have imagined at that time. Shall I proceed with my arguments, Your Lordship? Your Lordship, further, the Council would like to substantiate it with the case. In Cohen versus Paramount Pictures, the court held that even broadly worded licenses must be interpreted in light of the technology contemplated at the time of contracting. A 1969 license allowing use in any manner was held not to extend to VHS, as such technology was never within the parties' contemplation. Similarly here, technologies hereafter devised in the 1985 agreement cannot be stretched to cover AI-based voice synthesis, which fundamentally...
Counsel, will this case be binding upon us?
Your Lordships, the Council has referred to international conventions wherein there is a lack of jurisprudence and cases in the Indian context. The Council bases their reliance on the Vishakha judgment, Vishakha versus State of Rajasthan judgment. If Your Lordships could please refer to the compendium, tab 19. Are Your Lordships with me?
Yes.
Your Lordships, Article 51 promotes, talks about promotion of international peace and security, wherein Clause C mentions that fosters respect of international law and treaty obligations in dealing with the organized people with... Much obliged, Your Lordships. Your Lordships, in the absence of domestic laws and seeing much more legislative gaps in the AI domain, particularly in the Indian context, international laws can be referred to. Shall I proceed with...
The case you cited was by which court?
It was the Honorable Supreme Court, Your Lordship.
Okay.
Much obliged.
That case law is there, no?
Indeed.
Case law is there. Because these days, all these citations that you refer under artificial intelligence, we sometimes generally we don't find at all. Yes, it is there. You've gone through it.
Yes.
Yes. Can I ask you what is the ratio therein? What is laid down therein? Anyhow, forget about it. You can proceed. Yes.
Much obliged, Your
Yes.
Lordship. Your Lordship, if Your Lordships could please refer to flag 2 of the compendium. Your Lordships, this position is further reinforced by international law. Article 6 BIS of Berne Convention recognizes that moral rights survive death, including protection against distortion of identity. If Your Lordships could please proceed to page 20 of the compendium.
Counsel, that's not the entire clause.
The Berne Convention clause is mentioned explicitly on page 17 of the compendium.
The entire clause says subject to until the economic exploitation. Could you please read out the entire clause when you're referring to clause 6 of the Berne Convention?
reputation.
Clause 2.
The right granted to the author in accordance with the preceding paragraph shall after his death be maintained at least until the expiry of the economic rights and shall be exercisable by the persons or institutions authorized by the legislation of the country wherein protection is claimed.
Carry on.
Your Lordship, to substantiate it further, the reliance is based on page 20, the highlighted paragraph, Your Lordship. Your Lordship, voice of Pandit Rudra is a nationally celebrated artist whose recordings continue to be an irreparable element of India's living musical heritage, constitutes cultural heritage of the highest significance. Your Lordship, the cultural heritage would include the artist whose creativity and ingenuity is among the most valuable cultural resource of the nation. Through the telescope of section 57, it is possible to legally protect the cultural heritage of India to the moral rights of such artists. Your Lordship, moving on to the third limb of my submission that deals with the constitutional angle and gives the answer to the fifth question. Your Lordship, as this states, the issue is no longer contractual, it's constitutional. The present use goes beyond recording and enters into a real realm of identity exploitation, where speech is falsely attributed and identity is reconstructed without consent. This directly affects dignity and identity under Article 21. In the present case, Pandit Rudra consented to the use of his recordings, but never to artificial reconstruction of his identity or attribution to speeches he never made. Your Lordship, the present case falls under defamation, wherein speech is falsely attributed, reputation is harmed, and public is misled. The respondents may rely on Article 19 for their protection of their speech and expression or commercial trade. However, the Honorable Supreme Court has consistently held that where dignity is the foundation of all rights, and where Article 21 is gravely violated, Article 19 cannot be used as a shield to justify that violation.
Counsel, the respondents did not create defamatory material. They created an album. How is that considered defamatory material?
Your Lordship, the Council is referring to the deepfake incident on the Republic Day 2026.
Again, they were not the authors of the deepfake incident. Wouldn't you agree?
Your Lordship, but the very video derived from the platform is of Project Avaz, which was created by Swargunj and Nebula AI. Moreover, Your Lordship, in the Moot clarifications, second page of the MootCourt clarifications, it is explicitly mentioned in the first line. It explicitly states that the video included technologies using and it was generated using Project Avaz.
Okay. Again, how is Project Avaz defamatory?
Your Lordship, the video is defamatory in nature. We are directly imposing liability on the creators of such platform who did not impose reasonable restrictions on the very circulation of the video and generation of it.
So the argument is not that they have conducted defamatory action. The argument is that they have deep enough pockets. Is that the argument you're making?
Your Lordship, the Council still stands by their statement. The video was made by Swargunj Digital and Nebula AI's very platform, Project Avaz. It is indeed defamatory in nature. And further, Your Lordship, this will be dealt by my learned co-counsel in their subsequent issues.
Sure.
Your Lordship, shall the Council proceed to issue 2?
Yes, please.
Much obliged. The Council requests for the bench to please refer to flag 18 of the compendium. Are Your Lordships with me?
Yes.
Right, Your Lordships. Your Lordships, as held in the case of Titan Industries Limited versus Ram Kumar Jewellers, the law establishing a limiting principle where protection arises when identity is clearly recognizable. This limiting principle that protection applies only where 3 conditions are satisfied. One, identifiability. The individual's identity must be clearly recognized from the use. Here, the general public identifies the voice as Pandit Rudra's, and it is precisely this recognizability that enables the harm. Second, authorized use. There is no consent for that specific form of use. Your Lordship, there was no consensus addendum of both the parties on the use of generative AI. It is beyond the scope of the original assignment. Thirdly, demonstrable harm. There is real reputational, dignitarian, or public harm. Your Lordship, Rudra Heritage Foundation has suffered direct and tangible harm. A viral deepfake video has led to public unrest and vandalism of two of Rudra Heritage Foundation's cultural institutions. International agreements got cancelled of the foundation, students withdrew, and donations have also been cancelled. Your Lordships, this shows that identity continues to operate even after death, and so does the harm, affirming that this is not a speculative harm, it is a real, present, and continuing injury. Your Lordships, once it is established that identity continues, the next question is whether the law protects it. Reputation and identity are not abstract concepts. Reputation is protected under the ambit of dignity as established by the case of Board of Trustees. Your Lordships, further, it is submitted that Article 21 protects dignity as a continuing constitutional value, not confined to mere physical existence. In the case of Parmanand Katara versus Union of India, it was held that right to dignity extends even after death, and the dignified treatment of the dead is a constitutional obligation. It is a widely recognized principle, even under defamation, that reputation extends to deceased people posthumously and continues, and if it continues affecting surviving family. Your Lordships, these principles reflect a consistent...
See, just one clarification, that is after assignment of this right in 1985, no? 1985, till that incident of 2026, in what manner this, Swarganj was associated with this production or with this recordings?
Your Lordship, Swargunj and Nebula AI are the co-producers of the very Project Awaz platform. These Project Awaz platform uses the recordings of Mr.
No, not Swargunj. You are arguing on behalf of the Rudra Foundation.
Indeed, Your Lordship.
How Rudra Foundation was associated with this?
Your Lordship, indeed. If Your Lordship could please refer to the Moot proposition, para 2, artist and his legacy. Your Lordship, the last paragraph says, following his death, if the Council could please complete this very point, Your Ladyship. Much obliged. Your Lordship, following his death in January 2023, preservation of his artistic legacy and administration of residual interest came to be managed by the Rudra Heritage Foundation. It is a charitable trust, but it also functions as an administrative body that maintains the Pandit Rudra's identity and reputational interests.
No, that has got nothing to do with this. Your Rudra Foundation, once your right is assigned, sold, thereafter you have got absolutely no way involved. So that means never you asserted any right, be it moral right or personality right in whatsoever manner. It is only after that you have woken up.
Your Lordship, Section 57, Clause 2 vests the rights to claim moral rights in the legal representatives. Here, legal representative is the Rudra Heritage Foundation. The very chairperson of the Rudra Heritage Foundation is Ms. Tara Rudra, who is the daughter of Mr. Pandit Rudra.
No, that is, nobody can dispute that. Once you assigned it, you had absolutely never asserted right at any time in that recording of Mr. Rudra. So it is not your concern whether they exploit it by use of artificial intelligence or they, they misuse it. It is absolutely you are not affected, not harmed.
Much obliged, Your Lordship. The concerns of the bench are duly acknowledged.
Yes.
My co-counsels would be dealing with issues further.
Yes, sir.
Apologies, Your Lordships.
Yes. Yes, yes.
May it please this Honourable Court, the Counsel on behalf of the petitioner shall be arguing issue 3 and issue 4. Your Lordship's issue 3 pertains to determine whether an AI platform generating expressive outputs functions as an intermediary or assumes liability as a creator or publisher. And issue 4, Your Lordships, which pertains to determine whether machine learning training using commercially released recordings constitutes processing of personal data requiring renewed consent under the DPDP. With Your Lordship's kind indulgence, I shall now commence my arguments.
Yes.
Much obliged, Your Lordships. Your Lordship, the submission within issue 3 shall be presented in a twofold manner. Firstly, Your Lordships, that the respondent's role as an originator and active participant excludes it from intermediary status under section 79 of the RT Act that grants safe harbor. Second, Your Lordship, that the respondent's right to safe harbor under section 79 stands for patent. Your Lordship's Project Abbas is not a neutral intermediary. It is Schweighöfer's own proprietary generative AI, multimodal AI system, co-developed with Nebula AI and trained on datasets owned or licensed by Schweighöfer itself. Your Lordships, including approximately 300 hours of Pandit Rudra's recordings, it analyzes its vocal features such as breath patterns, resonance, microtonal variations, and tonal modulation, and then Your Lordship synthesizes entirely new outputs that never previously existed before. Your Lordship, Schweighöfer is not merely receiving or transmitting content here. Rather, it is generating synthetic performances in question and therefore does fall within the definition of an originator rather than an intermediary. Your Lordship, the Council shall be substantiating this with the very definitions of intermediary and originator as have been substantiated within the statute itself. Your Lordship, section 2, subsection 1, clause W. Shall we read it together, Your Lordship? Certainly, Your Lordship. Your Lordship, this section protects only those intermediaries that merely receive, store, or transmit electronic records on behalf of another without creating or curating said intent. Your Lordship, by this very contrast, section 2, subsection 1, clause Z defines an originator as any person who sends or generates an electronic message or causes any electronic message to be sent, generated, stored, or transmitted to any other person but expressly does not include an intermediary. Your Lordships. Your Lordships, furthermore, within the case of Shreya Singhal versus Union of India, within the very core of the judgment itself, 3 negative obligations regarding section 79 have been reiterated. If Your Lordships would please refer to flag 16, page 80 of the compendium. Shall I proceed, Your Lordships?
Page 80.
16. Shall I proceed, Your Lordships?
Yes.
Much obliged. Your Lordships, these 3 negative obligations are termed that the protection of intermediary, for the protection of intermediary, the intermediary must not 1. Initiate the transmission, 2. Select the receiver of this very transmission, 3. Select or modify the information contained in the transmission. Your Lordships, firstly, the transmission by definition. Your Lordships, transmission by definition entails dissemination of information from the source to the recipient. Your Lordships, the source here is the platform, Project Abbas itself, and the recipient being the user. Your Lordship, this, as has been established by the very factual matrix of the case, this model itself is a subscription-based model. Furthermore, Your Lordship, therefore, the respondents are initiating the transmission of this content merely by the very creation of Project Abbas itself. Second, Your Lordships, moving on to the very second limb of this negative obligation, the respondents are selecting the receivers. As established, Your Lordships, this is a subscription-based model. Furthermore, Your Lordship, by fixing the training corpus, choosing the stylistic parameters and branding the album as Rudra Reborn, it determines the space of these possible outputs. Your Lordships, the fact that the system is generating these very outputs probabilistically is not an automatic anonymization switch when the training corpus itself has been derived from the vocal preset of Pandit Rudra itself. Therefore, any generation that is even being done probabilistically in nature is pertaining to that very data that has been inputted. Therefore, it is not anonymized in nature. Lastly and thirdly, Your Lordships, the respondents are selecting and the respondents are not selecting or shaping the informational content within the transmission itself. Your Lordships, by fixing this training corpus and the stylistic parameters, apologies, Your Lordships, the second limb itself was pertaining to not the selection of the receivers, Your Lordship. The receiver was the paying user who had subscribed to this very model, Your Lordship, and Swargunj was deliberately offering these very outputs in a manner that could be easily disseminated. Your Lordship, these very negative obligations are not satisfied, thereby they are not granting any intermediary status to Swargunj or Nebulae AI here
Counsel,
itself.
could you compare and contrast these three features with any other entity that currently enjoys safe harbor status? Could you name me 2 more entities in the world that currently enjoy safe harbor status under Section 79?
Certainly, Your Lordships. Your Lordships, the Council is not very clear upon that very fact itself. However, Your Lordships, the Council would actually like to substantiate this very argument within a submission that has been made within the compendium itself. Your Lordship, within the current governance structure in India, Grok AI has been given safe harbor merely by stating within the very notification itself, Your Lordships, it is commonly referred to as the Grok notice. It has been issued by MAHE itself to X Corp. Within page 11, flag 20 of the compendium, Your Lordship, the Council has attached the very notification itself. Your Lordship, the regulatory provisions under the IT Act and IT rules, if not adhered to by platforms, will strip them of legal immunity. Within this very notification, Your Lordships, it was mentioned that these are not optional. These are obligations that must be followed, or else penal consequences will follow. Your Lordships, if Your Lordships require any further clarification, the Council would also like to rely on the case of Christian Louboutin versus Nakul Bajaj. Your Lordship, this case has been flagged in flag 6, page 36 and 38 of the compendium itself. Your Lordship, para 56 and 63 are pertaining to this very incident. The various factors that are enumerated within these paragraphs and the presence of these factors would hold the key to determining whether a platform is actually an intermediary or an active participant. Your Lordships, from the list enumerated within para 56 itself, pointers 8 and 10 are satisfied. Your Lordships, pointer 8 and 10 are pertaining to factors such as enrolling fee-paying members and advertising the products on the platform itself.
Please continue, Counsel. Carry on. Thank you.
Certainly, Your Lordship. Your Lordship, as has been established within this very case on the admitted facts, Swargunj is running Project Awaaz on the very subscription-based model. Finally, Your Lordships, the Republic Day incident is crystallizing this very position. Your Lordship, where a platform's own AI model is the source of the harmful, infringing work, after being trained and branded around a specific artist's identity, it can no longer be characterized as neutral. Your Lordship, therefore, the Council would like to contend here that safe harbor stands forfeited within this case, especially because the respondents here are not neutral intermediaries, but rather active participants within this case. If Your Lordships may permit, I shall like to move to the second limb within this very argument, where the Council will be establishing that due diligence obligations have not been complied with. Much obliged, Your Lordships. As exhibited by the notice within the compendium itself, Your Lordships, the Council shall like to further substantiate this with the advisory that had been issued on 15th March 2024 by MAHE itself, that reminded all intermediaries that due diligence extends to AI models, LLMs, and generative AI, and also advised, Your Lordships, that synthetic or deepfake prone outputs must be clearly labeled and embedded with persistent identifiers, while also warning that such non-compliance with the IT Act 2021 or the IT rules will invite penal consequences. Your Lordships, the Council would like to further substantiate this very advisory with another advisory as mentioned within page 94 of the compendium itself, which is the advisory of December 26, Your Lordships, 2023. Shall I read the highlighted portion, Your Lordships?
You are making this advisory applicable to the 26th events or earlier events?
The entire work of the platform itself.
How can be when this advisory is dated 23? Advisory is dated December 26, 23.
December 26, 2023, Your Lordship.
23.
Yes, Your
And
Lordship.
all these violations have taken place much before, earlier than that.
No, Your Lordship, the violations have taken place in 2026 itself.
Yeah, that you are confining it only to the 26th incident,
Yes,
not
Your
to the
Lordship.
others.
Your Lordship, the
And that's
advisory...
26 incident is no way connected to the other parties. There is absolutely no basis to link them at all.
Certainly, Your
You
Lordship.
do not know who has done it.
Certainly, Your Lordship.
What is the material to link them, the other previous parties?
Your Lordship, within the present limb itself, I am arguing the counsel here is referring to the impugned deepfake that had been propagated as established by the very factual matrix itself.
See, generally, this law should be applied to the facts, not facts should be applied to this law.
Certainly, Your
I
Lordship.
think you are reversing it, all these things, just because you want to build up an argument. I don't think that is permissible, because this is an advisory or the regulations of the 2023. You can't assail them. And these acts you cannot attribute to any of the respondents. 26 is an unknown person, we do not know.
Your Lordship, that is...
Only thing is that because it is containing the artificial images of that Rudra, you just link to them.
Certainly, Your Lordship, the Honourable Bench's concerns are noted, duly noted by the counsel here.
So one thing you can connect it, at least 25 release of that Rudra reborn.
Yes, Your Lordship.
Okay, you say so.
Certainly, Your Lordship.
Yes.
Much apologies, Your Lordship. Shall I proceed, Your Lordships?
Yes.
Much obliged. Your Lordships, the advisory, as mentioned here, Your Lordship, the advisory states that the terms of this very user terms that have been mentioned within the advisory of 15th March 2024, they must be clear and clearly communicated to the users. Your Lordship.
Counsel,
Certainly.
the advisory is due to intermediaries. I thought your entire argument was that they are not an intermediary.
Your Lordships, this argument is presented without prejudice to the above established facts within this case. We are arguing here, Your Lordships, even if the Honourable Bench allots them intermediary status, the safe harbour provisions do stand forfeited merely due to the fact that there is non-compliance with the due diligence.
Fantastic. What is the due diligence you suggest that they should be undertaking?
Certainly, Your Lordships. Your Lordships, if you may, please refer to the IT rules. Your Lordships, Rule 3, subsection 2, clause B. Shall I proceed, Your Lordships?
Yes.
Your Lordships, this specific rule requires intermediaries to publish their terms and make efforts not to host or transmit content that impersonates another person or misleads users about the very origin of this message within clause 4, F and G, Your Lordships. Your Lordships, applying this to the admitted cases, facts here, for an AI platform like Project Awaaz, that necessarily Swargunj has not complied with neither. Your Lordships, Rudra Reborn was marketed off of Pandit Rudra's entire identity persona with AI disclosures embedded deep within technical metadata. As has been established by the advisories before mentioned, Your Lordships, this does not satisfy the due diligence requirement that has been notified by the ministry itself. Furthermore, Your Lordships, no ex-ante safeguards were built to prevent Project Awaaz from being misused to create such harmful and infringing deepfake. Your Lordships, if the Council may, there are certain safeguards that must be placed in position before a project such as Project Awaaz, an AI platform, is being put to use that has the capacity to create such harmful and damaging content to a person's identity. Your Lordships, there was no mention of keyword filters, no verified users, and much more, Your Lordship, such as there were no robust mandatory watermarking of each content as AI-generated content. These are certain reasonable ex-ante safeguards that could be expected from intermediaries while deploying a harmful platform such as Project Awaaz. Accordingly, Your Lordship, an AI platform that is designing and controlling the very expressive outputs cannot claim to be a neutral intermediary entitled to Section 79 Safe Harbor, especially when statutory non-compliance is there with due diligence guidelines. If the councils have if the Honorable Bench has no further questions, the council requests permission to proceed to issue 4, Your Lordships, which pertains to determine whether a machine learning training using commercially released recording constitutes processing of personal data that requires renewed consent under the DPDPA. Your Lordships, this submission shall be presented in a twofold manner. Firstly, that the training of Project Awaz on commercially released recordings of
Council, I have a preliminary question. Now, you have a 1985 recording agreement. Are you saying that the DPDPA should apply to contracts that have taken place much before this particular time? Does it have retrospective application?
Your Lordship, the Council has duly noted the Honourable Bench's concerns here. The Act itself doesn't have retrospective, Your Lordship. However, the training itself is happening well within the ambit of the application of the DPDPA. The training itself is not happening in 1985. The training is very recent, Your Lordships, and that is why the Council for the Respondents here is contending that firstly, this very training, certainly, on commercially released recordings of Pandit Rudra does constitute processing of personal data, and furthermore, Your Lordships, the purpose is such that it does require renewed consent under the DPDPA. Shall I proceed?
Counsel, to add on to my sister judge's query, the earlier argument made by your co-counsel was that this was an infringement of copyright. Your argument is that there is an infringement of personal data protection. What is the subject matter of the data? Is it intellectual property or is it personal data? What is the value of it?
Certainly, Your Ladyship. Much apologies. Your Lordship, within this very contention here, we are contending that this processing of the vocal attributes, the data itself is falling under the ambits of the DPDPA owing to the very structure. If I may, Your Lordships, shall I proceed with my arguments? I shall elaborate as I move within the flow state.
Please make a reference to
Much
it.
obliged, Your Lordships.
You don't want to answer that.
I shall be answering that within the following submissions, Your Lordship. Much obliged. Your Lordships, at the threshold, Pandit Rudra's studio's recordings are personal data within this very definition of the DPDPA. Your Lordships, if you may refer to Section 2, Clause T of the DPDPA, shall I read it for the Honourable Bench here? Much obliged, Your Lordships. It is data about an identifiable individual or that is in relation to such an individual. Your Lordships, these are commercially released recordings here under his name, linked through catalog metadata, and even without that, embody a unique acoustic signature such as tonal modulation, breath patterns, resonance, and microtonal variation. Your Lordships, these very attributes lets the listener recognize him immediately. Furthermore, Your Lordships, if we were to analyze the pre-DPDPA framework, within the Rule 2, subclause B of the IT rules, SPDI rules, Your Lordships, the Sensitive Personal Data or Information Rules of 2011. Biometrics means the technologies that measure and analyze human body characteristics such as voice patterns and etc. Furthermore, Your Lordships, within this very Act, Rule 3, subclause 6 includes biometric information as sensitive personal data. Your Lordships...
These very same rules, they have constituted or established a separate machinery to work out for the remedies.
Pardon, Your Lordship?
There are separate appellate board or all other agencies for redressal. You have not approached any one of them.
Certainly, Your Lordship. Your Lordship, the issues were presented before this very bench.
How you can challenge it when there is a specific machineries are provided or established under the Act? You should exhaust that. Then otherwise, at least your Moot proposal should give some kind of justification for you to directly. You have only suit your file, no? Suit or PIL?
Certainly, Your Lordship. Within that,
you have filed suit or PIL?
Your Lordship, the Moot proposition itself is silent on that very aspect here.
No, what do you say that? Well, can you justify that? In the face of this, when there is separate remedy is provided, can a party directly approach under the general law?
Your Lordship, if the Council may, if the Honourable Bench could refer to the very last, apologies, Your Lordship.
Yes. Whether the jurisdiction of the court is not barred under this act?
Your Lordship, the CGI himself has taken all these matters before the proceedings owing to the imperativeness and pertinence of these issues here. Your Lordships, as established within this very limb here, this is sensitive personal data. Biometrics or these vocal attributes that are being invoked here are personal data. And furthermore, within the very definition of the DPDPA, do constitute this very processing. Your Lordships, our core submission here is that once Project Awaaz is deployed, every use of the ascetic preset and every Rudra-like output is a fresh act of this processing of personal data under the DPDPA, and therefore it must qualify purpose limitation as has been defined under Section 6, subsection 1 of the DPDPA itself.
Counsel, going by that, every recording, every photocopy of the Mona Lisa is going to produce a fresh requirement for consent of personal data processing.
Pardon, Your Lordship?
A painting, brush strokes of a painting, are equally found to be indicative or identifiable of the original artist. Are you telling me that if I take a picture of the Mona Lisa, I will then be processing the personal data of Da Vinci?
Your Lordship, within this very contention here, what is being argued is that the vocal attributes that have been used here fall within personal data.
And I'm saying paintbrush strokes are also identifiable of an artist and so would be constituted as personal data under the DPDPA. So my question is, where does this end? Once an artist has been given a commercial contract and is given rights to commercially exploit his production, beyond that, saying that every subsequent photocopy will also require, or every subsequent adaptation will also require you to get consent again, this makes it a continuing right. Then what did Swargunj or Magna really pay Pandit Rudra from? If I understand correctly, Rudra Heritage has economically benefited from the exploitation of the songs further since. Unless Rudra Heritage is making this argument entirely on principle and is saying you don't want money from the recordings at all, that's a completely different argument. But here, if you are enjoying the benefits of the commercialization of this product, you cannot turn around and still say that you want to establish violation of consent or that a fresh consent is required due to Rudra Heritage. This negates the original purpose of the contract.
Certainly, Your Ladyship. Your Lordship, if I could seek an extension of 2 minutes to answer this very question. Your Ladyship, this has been very correctly pointed out by this honourable bench here. Your Ladyship, the question here is the purpose, the underlying purpose, as has also been mentioned within Section 6, subsection 1 of the very DPDPA Act. Your Ladyship, if the purpose is differing from the originally agreed upon purpose, there needs to be fresh and renewed consent.
So your entire argument for DPDPA violation is that the vagueness of the contract clause is what allows for you to seek redressal again, seek consent again?
Your Ladyship, the vagueness of the contract, moreover coupled with the fact that the consent has not been given to AI-generated outputs. Your Ladyship, these are synthetic creations.
The entire argument, your entire bedrock of your argument rests on the fact that Pandit Rudra could not have seen AI coming. The language used broadly talks about as in hereinafter devised. The very objective is to say that, or else they could have just listed exhaustively the technologies currently in place. The idea of saying hereinafter, thank you, as hereinafter device specifically contemplates technology which is otherwise not recognized as of date, or else there's no need for that clause. Agreed? Further, Pandit Rudra died in 2023. At no point before his death was this clause challenged. Understandably, this clause was created, or the platform was created in 2025. But before 2023, when there were multiple variations or in the knowledge of this technology arising, this clause was never challenged. And to my understanding, there has been no reference that the Rudra Heritage Foundation is declining any proceeds from any of these activities.
Certainly, Your Ladyship, much obliged. Your Ladyship, if I may, the respondent's contention, the very contention here, that the original purpose of the contractual assignment was the commercial exploitation of the works, not the production of new or synthetic outputs. If I may seek an extension of 2 minutes, Your Ladyship, much obliged. Your Ladyship, this process that is taking place here is not a mere evolution in playback technologies. Rather, it is a shift to a new identity-linked technical purpose, which cannot be justified either by the contractual assignment or under this DPDPA. That is what the Council's contention here is, Your Ladyship, that the purpose itself has been altered. There was no consent given for this very AI-generated purpose. That is what the Council is contending here, Your Ladyship. Moreover, coming over to the argument that the clause itself was never challenged within Rudra's lifetime, Your Ladyship, the Council here would like to contend that the cause of action has arisen after his death.
I'm not challenging that. That's not my argument at all.
Your
The
Ladyship.
whole context is that it was not contemplated by Rudra.
Certainly, Your Ladyship.
Well before he passed away, the new era of generative AI had started. So if the argument is that AI was not contemplated by Rudra in his lifetime, I would disagree with that, but we can carry on.
That is what the Council here is contending, Your Ladyship, owing to the very new purpose that has been invoked within this very activity of deploying Project Awaaz. That is why the Council here is contending that it does constitute processing of personal data and it must require renewed consent under the very framework.
Argue that the cause of action did not arise. I'm aligned with that. That it was not contemplated in 1985 is no longer relevant.
Pardon, Your Ladyship?
The fact that generative AI was not contemplated by the author, by Rudra, at the point of signing the contract and until his death is not relevant if you're saying that the cause of action didn't arise then. Those are two separate activities. Please carry on.
Certainly, Your Ladyship. Your Ladyship, Rudra himself only consented to the commercial exploitation as has been established within the factual matrix itself, and the entire argument of the respondent's contention within this particular issue relies on the fact that there is a new purpose, and that is what the Council is contending. Your Ladyship, Your Lordships, the Council seeks permission to proceed to the prayer. Much obliged, Your Lordships. Your Lordships, wherefore, in the lights of issues raised, arguments advanced and authorities cited, it is most humbly prayed before this Honorable Supreme Court of Indica that it may be pleased to declare that the unauthorized AI-based use of the voice and identity of Pandit V.N. Rudra is violative of the Constitution of Indica, grant a permanent injunction restraining the respondents and all persons acting on their behalf from creating, disseminating, or using such content based on his identity. Pass a John Doe Ashok Kumar order restraining unknown persons or intermediaries from creating or hosting such content, and declare that Clause 14B, insofar as it extends to generative AI, is void and unenforceable, and or pass any such orders, issue any such directions, or grant any such reliefs that it may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioners, as in duty bound, shall be most humbly obliged, all of which is most respectfully submitted. Thank you.
Yes.
Thank you.
Greetings to the bench. This is counsel number 1 appearing on behalf of the respondents. In the case of, am I audible?
Yes, yes.
This is counsel number 1 appearing on behalf of the respondents in the case of IPRS and another versus Union of Indica and others. For the sake of brevity, the council seeks permission to address the bench collectively as your lordships and individually as your ladyships and lordships. Much obliged, Your Honor. So in this instant case, the council would be arguing the first 3 issues in the said fact sheet, and council number 2 would be arguing the last 2 issues in the said fact sheet. If it
You are
is-
clubbing them because they are numerically written that way, or is there any reason to club the issues together?
It is not being clubbed, Your Lordships. Here in this instant case, the first, second and the third issue would be
issues will be
dealt
answered,
by
that's
the
all.
Council number 1, and the fourth and the fifth issue will be subsequently dealt by Council number 2. In this instant case, Council number 1 wishes to proceed with her arguments advance. Yes, indeed, Your Lordships. Whether a contractual assignment covering technologies now known or hereafter devised includes generative AI capable of producing synthetic performances resembling an artist's voice. It is humbly submitted before this Honorable Supreme Court that this indeed allows this contractual assignment indeed covers technologies now known or hereinafter devised and includes generative AI in its ambit, Your Ladyship and Lordships. In this, the Council would like to direct the bench to clause 14b, which clearly reads that the artist assigned to the company all rights, title and interest in the master recordings and performances embodied therein. The first part of the contractual assignment clearly states all rights, title and interest, Your Lordships. Here in this instant case, further when we go into the contract, it reads including exploitation. When the word including is included in such a contractual term, it clearly means that it is not an exhaustive list. So anything following the word exploitation cannot be given an exhaustive format or an exhaustive list, Your Ladyships and Lordships. Here, it states that including exploitation through mechanical, electronic, digital or other technologies now known or hereafter devised. So this term including exploitation must be given a wider import and read with the clause now known or hereafter devised. When all rights and titles and interests therein in the master recordings are already transferred to that of the respondents, along with exploitation rights in further continuation of any technological developments that may be there in the future, it must be given a wider import. And for this, the Council places reliance upon the case of Harsha Nitin Kokate versus Saraswati Co-op Bank Limited in page number 120 of the compendium provided to the bench in paragraph number 2, which clearly states that if a person holds a legal right, whenever the bench is with me, Your Lordships,
Page 120.
page number 120 of the compendium, paragraph number 2.
Yes.
Yes, indeed, Your Lordships. Here in that particular case, it was held that a person, when they hold legal right, all legal rights, title and interest, they are entitled to own the said property as their own. So, this assignment...
Which paragraph is it?
Paragraph 2, Your Lordships, page number 120.
That is narration of facts, not the law laid down.
Here, it clearly states that the plaintiff must show her legal right, title and interest in those shares, and if that is shown, the plaintiff would be entitled to sell or transfer those shares or to hold them as her own. So, in this particular instance, the court held that the moment the plaintiff shows all legal rights, interest and title in the particular shares, she can hold it as her own.
Does
And
this decision lay down any law? Either with regard to interpretation or with regard to the applicability of any provisions. It is application to the facts of that case. Nothing, I don't think it is a...
The Council
reliance
is
itself.
merely trying to rely on this, Your Lordships, for an understanding and as to how the interpretation of including exploitation and all rights, title and interests have been perpetrated by that of several high courts. It is not with respect to a law or a law point that can be applicable here, but the different type of interpretations taken by several high courts and the persuasive value of the same
Okay, you have
before
got
the Supreme
better
Court.
decision, only that decision on that point.
The Council would like to further rely on other decisions as her argument proceeds. And with respect to the same, Your Lordships, including exploitation, like the Council had previously mentioned, clearly does not indicate an exhaustive list of only modes of dissemination. When, like Your Ladyship had previously mentioned, there is generative AI. And when Pandit Rudra passed away, there was a development in generative AI. And through the years from 1985 till 2020, 2023, there have been several technologies that has been devised. So this particular clause should only be read in consonance with the term including exploitation, wherein it cannot be read with the modes of dissemination. And in understanding of the same, the council would like to further rely on the case of...
Does this also, extend to defamatory kind of work that has happened because of this?
Your ladyship, if pardon me, please.
The defamatory kind of statements that have come out, no? Because of, as the petitioners have said, which is a violation of both the Berne Convention and BNS, I think section 356 is what they have claimed.
Yes, indeed, your ladyships. Addressing the further question of defamation in this instant case, the counsels for the petitioners had intended and relied upon the facts of the deepfake video being released by that of the respondents on their platform. But the council would further submit in her next argument, in the next issue, that there has been no involvement of the respondents in creating such a deepfake video. So any defamatory case that might arise out of that will not be attributable to that of the respondents in itself, your lordships, because in this particular instance, if the respondents in arguendo had did something which was out of their power or which was out of the realm of their intermediary space to create such a deepfake video, then they can be attributable. The legislative intent behind the creation of section 79 and the safe harbor clearly excludes the respondents from any imputation of liability on them for the creation of the deepfake video or any defamation case arising out of that deepfake video, your ladyship.
We'll get into that in further detail.
Yes, indeed, your
but
ladyship.
quick question. What is the distinction you are drawing between exploitation and dissemination, and to what end?
Yes, indeed, your ladyships. Here, if the council may read in verbatim the clause again, it states that including exploitation through mechanical, electronic, digital or other technologies now known or hereinafter devised together with the rights of editing, adaptation, remixing and commercial dissemination. Commercial dissemination refers to several other modes of dissemination commercially. Like for example, publishing such audio or like marketing such audio when Rudra recorded it or something of that nature will amount to commercial dissemination. But the word exploitation can only be read with the clause of now known or hereinafter devised. The phrase of now known or hereinafter devised, because exploitation refers to the technological exploitation that may be conducted. And in furtherance of the same, the council would like to further submit two last cases and sum up the argument and proceed to the next issue. The ABC Laminate versus AP Agency Salem clearly stated that the express use of words like all rights, exploit, all rights and exploit remove any ambiguity in a contract. So there must be given a plain interpretation or a literal interpretation, your lordships. And in furtherance of the same, the council would also like to state the case of KK Singh versus Murthy Devi in page number 126 of the compendiums provided.
The right to exploitation means even the very identity itself you can destroy it. So to that extent you can go. That is what you mean to say.
Here
because you have been given the right to exploit, so the very person which give you the right, you can destroy his very identity itself and can make a totally different...
The council is merely trying to state that here in this instant case, the exploitation refers to the artificial intelligence training for which the recordings have been used. The council will be further dealing with the identity under the publicity rights issue under Article 21 and how that will not fall under this particular ambit as well, your lordships. If your lordships are satisfied, the council would like to further sum up her argument by stating the case of KK Singh versus Murthy Devi in page number 126 and paragraph 18 of the compendiums presented before your lordships. Whenever your lordships are with me. It states that if the language is clear and unambiguous, there must be a literal interpretation involved. If the lordships have...
Which is the paragraph? 18.
Paragraph 18, your lordships. Just a minute, your lordships.
It is cardinal principle. The language employed in this is clear and unambiguous. The common literary meaning ought to be assigned in interpretation. Okay, this is what I first itself I told you. Yes. If the language is very clear and unambiguous, nothing, no scope for interpretation.
Yes. The council humbly agrees with your lordship on this.
What do you have to say to their... Sorry, what do you have to say to their argument on moral rights?
The council will be dealing with the moral right arguments in the next issue with respect to personality rights as well, your lordships. The council would like to further move on to the issue of whether personality and dignity interests protected under Article 21, survive death and limit posthumous commercial exploitation through artificial intelligence systems. The Council humbly submits before this Honorable Supreme Court two prongs of arguments, stating that there is no posthumous applicability of publicity rights, and in furtherance of the same, there is no moral right violation in this instant case. The first case being, when there is publicity rights involved, your lordships, it emanates from the fountainhead of right to privacy under Article 21. The right to privacy landmark judgment is case Puttaswamy versus Union of India, where it was held that, if I may read in verbatim, that the right to privacy of any individual is essentially a natural right which is inherited in every human being by birth, and such right remains with the human being till he or she breathes last. So it is very clear that the right to privacy extinguishes upon death. So
why are you saying that the right to publicity comes from the right to privacy?
Yes,
It can coexist. Why do you say that the right to publicity emanates from the right to privacy?
Yes, indeed, your lordships. There have been several cases filed upon posthumous publicity rights before the Madras High Court, before the Bombay High Court, and several other high courts throughout the government of India. In that particular aspect, all of these high courts had clearly stated that the right to publicity comes or emanates from the fountainhead of the right to privacy under Article 20.
Could you reference a case where that's mentioned?
Yes, indeed, your lordships. In the case of Deepa Jayakumar versus A.L. Vijay, the Madras High Court categorically held that it is clear that a privacy or reputation earned by a person during his or her lifetime extinguishes with his or her death. This is given in page number 96 of the compendium.
No. Could you refer to where it says that the right to publicity emanates from the right to privacy? Your argument is that because the right to privacy has been curtailed on certain grounds of life, right to publicity and emanating from that should also have the same caveats or should have the same boundaries. And my question to you is, how are you stating that the right to publicity emanates from the right to privacy?
Yes, indeed, your lordships. The council seeks a second to just refer to the judgment. In the case of the Managing Director Makkal Tolai Thodarpu versus V. Muthulakshmi, and in the case of Deepa Jayakumar,
Is this in your compendium?
yes, indeed, your lordship. In the page number 69 of the compendium, and in the case of Deepa Jayakumar versus A.L. Vijay, I would like to state the case in verbatim, your lordships. Just a minute.
If you're referring verbatim, request you to direct us to the page.
Yes, your lordships. Just a minute. It is stated in paragraph number 26, your lordships, that it emanates from the right to privacy in itself.
No, we don't have the Deepa Jayakumar case. Could you refer to where the page number you're referring to?
Yes. Yes, indeed, your lordships. Page number 96 of the compendium.
Yes.
Yes, continue.
In paragraph number 26, before the last couple of lines before the paragraph number 27, it states that the alleged right sought to be enforced by the present appeal is the posthumous right of privacy to protect the dignity and the legacy of the appellant's aunt. It is a settled proposition of law that the right to privacy of an individual extinguishes upon the human being. Accordingly, any action to exercise posthumous right of privacy is not maintainable, but to buttress the submission, reliance was placed on the judgment of the Supreme Court of K.S. Puttaswamy versus Union of India.
Was that my question?
And this is
Was that my
submissions.
question?
See, what you are reading is the argument or the submissions of the council. That is not the decision of the court. So you must be able to distinguish very clearly what is the...
Yes, indeed, your lordships.
So that is not the decision of the court.
Furthering your lordships to the exact paragraph in which K.S. Puttaswamy, where it stated that publicity rights emanates...
Yes, tell me exactly where it stated that publicity rights emanate from the right to privacy.
Yes, indeed, your lordships. In page number 98, in paragraph number 34. It stated that the disclaimer is not a biography of any character. Moreover, the right to privacy of an individual extinguishes with a human being. It can be very categorically seen from all these judgments that the right to privacy is where the right to publicity emanates from.
I don't see that at all.
See, para 38 is the one. See, earlier what has been reproduced is only the citations or the argument. On analysis of the aforesaid judgments, it is clear that a privacy or reputation earned by a person during his or her lifetime extinguishes with his or death. After the death of a person, the reputation
indeed,
earned cannot be earned. That is law.
Yes, indeed, Your Lordship.
Yes.
Even paragraph 38 is also being relied upon by that of the respondents in this instant case.
Cannot be
Paragraph
inherited
38 along with paragraph number 24 and 34 is being relied upon by that of the respondent.
You're making the respected judge make an argument on your behalf, right?
Indeed not.
It's very effective on you, by you.
Apologies.
Yes. Yeah. Yes.
In any case, this is all on privacy. Anything to say there is no posthumous right of publicity?
Your Lordships?
This case you relied on is that there is no posthumous right to privacy. Is there something saying there is no posthumous right to publicity?
Yes, indeed, Your Lordships. All these cases that were filed before various high courts were relating to the posthumous applicability of publicity rights under the head of right to privacy. So, in that particular aspect, it was stated that the right to privacy of the person who had passed away had also been violated along with their publicity rights. It was held by these courts that the right to privacy or the right to publicity does not exist posthumously and extinguishes upon the death of the person.
Counsel, you'll forgive me if I think that there's a lot of narration happening over here. You're not able to point to where exactly this has been referred to. The senior judge then referred to the right to privacy and reputation.
Yes,
right to
indeed.
publicity is possibly a very liberal interpretation that you're taking.
Your Ladyship, I would like to further state that the right to publicity or personality rights is also that also includes the right to reputation under its ambit, because it personally refers to the likeness or the persona of the person who is being involved in this said problem. So in that particular aspect, the right to privacy and reputation has been addressed by the case of Deepa Jayakumar versus A.L. Vijay, and in the case of Makkal Tolai Thodarpu versus V. Muthulakshmi, where Veerappan was not given a posthumous right of privacy, and it was stated that since he was a widely known popular figure, there can be any interpretation on his life, and there can be a web series made out of his life, and the people that were entitled to the right to privacy were only his wife and his child.
These were all high courts so far?
Yes, indeed.
Clearly not binding on us, right?
It has persuasive value alone, Your Lordships. In continuation of the further, the Council would like to further move on to the last limb of the said issue as to how there would be no moral right violation under Section 57. Under Section 57, it states that for a moral right violation to occur, there must be a distortion or a mutilation of a specific work, Your Lordships. Here, there is no specific work of Mr. Pandit Rudra that is being destroyed or mutilated. The Council would like to further refer to the case of Raj Rival versus Union of India, where it was stated that only when there is complete destruction.
Where is the page number? You are now submitting.
Council seeks.
No, Kodiyadu. Yes, sir. Hello. Just. Yes. Oh, only one copy. Yes.
The Council apologizes for the
Yes,
same. The Council seeks to place a reliance upon Raj Rival versus Union of India, where it was held that complete destruction of a work, where it cannot be seen, felt or touched, cannot have any moral right violation or implication on that of the author. In this particular instance, the Council is trying to state that there is no work or there is no composition A of Mr. Pandit Rudra or composition B of Pandit Rudra that is being implicated into that of the AI system to distort it or mutilate it to generate a new version. Here, there is a completely new version generated on statistical probabilities and not out of stored recordings as per the fact sheet under paragraph number 4. And it is also stated that the developers asserted that the model was merely probabilistic and was trained on acoustic attributes which was converted into statistical parameters. So when it was introduced into that of the AI system, it became statistical parameters and merely numbers and could not be identifiable to one particular person or one particular work done by that person. So when there is no one particular work that is being destroyed or mutilated, there can be no moral rights claimed under section 57 to begin with, your lordships. So in this, in the furtherance of the same, the council would like to rest her arguments that there is no moral right violation if the lordships do not have any further questions on this aspect and would like to move on to the intermediary issue. The council would like to further state that AI platform generating expressive output functions as an intermediary entitled to safe harbor protection or assumes liability as a creator or a publisher. It is stated that here this AI platform should be given a safe harbor protection and does fall under the definition of an intermediary as per section 2W of the IT Act. Section 2W reads an intermediary with respect to any particular electronic records means any person on behalf of another person who receives, stores or transmits that record or provides any service with respect to that records. So in that particular aspect, the words any service with respect to must be given a wider import. So here in this case, when it reads any service, that service may be creation or generation. In this instant case, this AI platform helps in creation or generation. As per the rules, the IT rules of 2026, under Rule 3, Subclause 3.
Before you go to IT rules, what do you have to say on that point about the 3 elements of 79 not being satisfied?
Yes, indeed, your lordships. The council would like to further move on and state that the council would like an extension of 3 more minutes to complete her submission on this issue. The council would like to further move on and state that when such wider import is given under 2W, automatically they fall also under the ambit of section 79. The legislative intent of creation of section 79 after the case of the Bussy.com was to make sure that there is no intermediary or no party that is that has not contributed any significantly or even mildly to that of the creation of an unlawful content is subjected to liability. Here in this instant case, there was an unauthorized third party who misused the app. So this was the primary legislative intent in granting safe harbor in itself.
Your whole argument is that the term provides any service as a definition of intermediary should be interpreted widely and should include any service, including when you as a platform are creating a technology or creating an enabling system whereby defamatory action can be taken specifically.
The council would like to further rely upon Rule 3.3 for the said arguments, where the 2026 guidelines clearly state that where an intermediary offers a computer resource which may enable, permit or facilitate the creation, generation. The rules clearly allow any intermediary which enables, permits or facilitates and offers a computer resource for creation or generation. Here, there is merely an offering of a resource for creation or generation by that of the respondents. Therefore, the AI platform under the rules and under section 2W along with section 79 can form a safe harbor protection under section 79.
But then by your definition, anybody who provides any material can come under the definition of intermediary. What is then the distinction between somebody? Let's go by your definition. By your definition, tell me somebody who is not an intermediary.
Your ladyship, according to this definition, who would not be an intermediary would be a person who does not do any account or provides any services on behalf of another person. If this party provides services on behalf of their own platform or anything with respect to them, then they lose then they do not fall under the ambit of an intermediary.
Fantastic. You have created a platform wherein it is possible for anybody to create content which is towards the likeness of Pandit Rudra by design. It's called the aesthetic, it's called Rudra Reborn. You're not shying away from the fact that you're trying to impersonate Rudra and trying to ensure that this project of ours where people can come, sign up, create like a happy birthday song in the voice of Pandit Rudra. Do you agree that that is very much the intent of the platform?
Indeed not, Your Ladyship. The Council would like to further rely upon facts in paragraph number 4, where it clearly stated that the platform's terms stated that generated outputs were synthetic creations derived from statistical modeling and did not constitute performances of any natural person.
That's not what I said.
The Council would like to further go ahead and state that here the album that was created was titled Rudra Reborn. The album, the preset was titled the aesthetic preset. But in that instant case, it cannot be meant to say that it was impersonating a person, primarily because that impersonation was derived from the aspect of publicity rights. And when his persona becomes publicly available, it is just mentioned that it is called Rudra Reborn. There is no specific aspect that is linking his voice. The AI model is trained on statistic probabilities and not on the voice of Pandit Rudra, where it can figure out that this is the voice of Pandit Rudra.
That's an error. It was definitely trained on the voices of Pandit Rudra. The output was a statistical probability and was not a version of Pandit Rudra's recordings. That's the best that you can claim. You can't say that it was not trained on Pandit Rudra's recordings.
It was trained on Pandit Rudra's recordings as a statistical probability is what the Council is trying to state, Your Ladyship. Here, if I may refer to the facts again, where it states that the training process analyzed acoustic attributes, converting these features into statistical parameters. So when it states that it is converted into statistical parameters, when it is inputted into that of the AI system, it merely just becomes numbers, Your Ladyship. It does not refer to the identifiability of this person in general, when it is inputted into that of the AI system. And it also states that the system was trained using catalogs owned or licensed by Swargunj, including Pandit Rudra's catalogs. So it was not only Pandit Rudra's that was being used to train. There was only mere training data available to that of Swargunj from their catalog, which they took to use and train the AI model. And in furtherance of the same, the Council would like to further go ahead and state that under section 79, the Council seeks an extension of a minute. Under section 79, when an intermediary initiates the transmission, modifies or selects the receiver, then they automatically fall away from the safe harbor protection. But here in this instant case, this unauthorized misuse was done by a third party. To answering Your Lordship's questions further with respect to 79 and how it implicates. So here there was no initiation from the side of the respondents, wherein they did not create the deepfake video. There was no selection of receiver. It was viral. It was made viral on various social media platforms. I did not select the receiver as to stating that this person will receive this deepfake video. And when there was no selection or modification of the receiver or initiation of the transmission, I do fall under the very ambit of safe harbor, even under section 79, along with the due diligence principles under rule 3.3 of the 2026 rules as well, in accordance with 2 subclause W of the IT Act. If Your Lordships are convinced with the argument, the Council would like...
No, you mean to say that, see, ultimately the outcome of it is they produce 2 statistical parameters. With the use of it, you say there could not have been any impersonation. Is it not? First your argument in reply to that, you said there could not have been. But in effect, there is impersonation.
There is no impersonation per se, Your Lordships. Here in this case, the Council is merely trying to state that when the catalogs owned by Swargunj were used for training, including Pandit Rudra, it states that not only Pandit Rudra's recordings were used, several other people's recordings were also used, but which was licensed by that of Swargunj. So they had the copyright in order to use this particular data and for training purposes, not for impersonation purposes, but for training purposes. Here, there is no particularized impersonation because it clearly states that it was not out of stored recordings, or it was merely based on statistical probability. So at that point, when it is stored recordings, then there can be impersonation. If I am taking composition A from Mr. Rudra and putting it through this AI system to transform and create something which is distorted or mutilated, then I am impersonating Pandit Rudra.
I quote,
Then
the system, sorry.
Yeah. This how this impersonation took place? Do you mean to say by coincidence or by fluke chance?
System was trained using catalogs.
Yes, that's right. No, what she says is that because what they have done is by using while training, it was converted into a statistical parameters. Therefore, there was no possibility of a what you call. That's
indeed.
what you said.
Yes, indeed.
But in fact, now that possibility has been materialized. Is it by chance or by using the same what you call statistical parameters? So that means necessary safeguards were not provided.
Your Lordships,
It was prone to be misused.
Your Lordships, in this further response, the Council would like to state that this impersonation question came into play in with respect to the 26th January 2026 deepfake video that was created. That was indeed, like the petitioners had mentioned, given in the clarification that it arose out of the platform of Project Aavas. But in this instant case, it also states under the 6th paragraph stating that the video spread rapidly before verification mechanisms could intervene. So at that particular point in time, before there could be any due diligence mechanisms or takedown mechanisms that were actually put into place, or when actual knowledge came to be to that of the respondents, before they could do anything, it rapidly spread, Your Lordships.
I refer to paragraph 5. Reference to the artist's legacy appeared in promotional materials while disclosures identifying AI generation were included within technical metadata. Rudra Reborn was the precursor to the abuse to Project Aavas. You cannot say that at the point of Project Aavas being misused on the Republic Day on 26 January 2026, that you could not foresee it or it was not intentional. The entire album of Rudra Reborn, which achieved significant commercial success, was the ramp up to the abuse on Project Aavas. And Rudra Reborn was created specifically with the intent to impose upon the public an instance that this was linked to, or to create an impression that the music being heard was linked to Pandit Rudra at the very least.
Your Ladyship, the Council humbly begs to differ on Your Ladyship on the point that it is well known as a fact that Mr. Pandit Rudra passed away in 2023.
Agreed.
So any impersonation or alleged impersonation by that of the petitioners, it is very clear that the respondents did not want to actually link it to Mr. Pandit Rudra's original recordings.
Then why have have references to his legacy in the promotional material?
Your Ladyship, in that particular instance, when it is titled Rudra Reborn, or where any reference is made to his artistic legacy, all of it becomes publicly available. Today, Your Lordships, all these celebrities are publicly...
That's not the question, Council. That's not the question. The question is, at the point of release of Rudra Reborn, there was a specific, categorical intent by your party to ensure that the public was perceiving the album as being linked to, or in fact the recordings itself of Pandit Rudra.
Indeed not, Your Ladyship.
Why not?
Because the Council would like to further state again the same facts of the MootCourt proposition, where it states that the platform's terms stated that the generated outputs were synthetic creations derived from statistical modeling and not out of natural person. So in that particular...
Council, either you're not understanding the question or you're trying to mislead the court.
Indeed not, Your Ladyship. The Council apologizes. The Council is merely trying to state that the respondents did not intend to state that it was a performance done by the natural person of Rudra himself. That is why it is mentioned in the platform terms. And here, any reference to promotional material with respect to his name, it's primarily the aspect of his name being publicly available. That cannot be disputed, and that impersonation or that imputability of impersonation cannot lie on that of the respondents, primarily due to the reason that it does not relate to him as publicity anymore, because there is no posthumous applicability of publicity rights in this instant case.
Anyhow, it is there in black and white. What is there in it is Rudra Reborn. You are proclaiming it in this one. It speaks for itself. Is it not? Your intention is motive, need not to run here and there to gather. It speaks for itself. You want everyone to invite by the name of, to resurrect Rudra by this, artificial, by this album.
It
so
was
our intention is very clear. When it is there in black and white, where is the scope for arguing it and giving a meaning to it? Is it not? It's difficult.
Humble apologies to the bench, Your
No,
Lord.
no, you can go ahead with the persuasion. Don't worry. You have been very persuasive that you are entitled to do that. Just because we intervene, we ask you don't do this one. What we said that, yes.
Time is up.
Time is up. Yes.
The council would like to further conclude and state that they very well fall under the ambit of an intermediary under
Yes,
section
yes,
2W
we appreciate that.
and
Yes.
follow
Okay, I
through with
think
the
time
safe
is out.
harbor
I
under
think
section
time is out.
17.
I think next son. Yes.
Thank you. Much honored, your leaderships.
Yes. Sir.
May it please the Honorable Court, this is Counsel number 2 appearing on behalf of the respondents, and Counsel number 2 will be dealing with issues number 4 and 5. With the permission of the bench, the Counsel would like to proceed to issue number 4. Much obliged, Your Lordships. Whether machine learning data using commercially released recordings constitute processing of personal data requiring renewed consent under the Digital Personal Data Protection Act. Your Lordships, in 1985 is when the agreement between Mr. Pandit Rudra and Swargunj Digital was taken place. Here in that agreement, it categorically transferred all rights, title and interest relating to the master recordings and performances embodied therein. And the consent was obtained in 1985. To apply an act that took enforcement on 13th November of 2025 to an agreement which got its consent under 1985 contract would be a retrospective application of the DPDP Act in itself, and which is not prescribed by the Act, because unless a specific provision or the legislation in itself expressly provides...
No, it didn't follow. What is that? What exactly you want to say?
Your Lordships, what the Council is trying to state that the petitioners are trying to apply the DPDP Act, which took its enforcement on 13th November of 2025, to an agreement that got its consent in 1985. In 1985 is when the rights, title and interest were transferred to the respondents by the contract between Magna Recordings and Mr. Pandit Rudra. To apply the DPDP Act, whereby they have to seek consent to an agreement that took place in 1985, it would mean a retrospective or a retrospective application of the Act. And unless the legislation expressly states that the Act is retrospectively applicable, we cannot put a retrospective application on a 1985 incident. To this record, Commissioner of...
You mean to say this Act is not applicable?
That is the primary argument placed by the respondents, because the incident of transferring this right took place in 1985.
These are simple words you can say. Yes.
Indeed, Your Lordships, indeed.
There is a continuing use from November 25 onwards.
Indeed, Your Lordship.
There is a continuing use.
Your Lordships, the DPDP, the purpose for which all of the rights, title and interests were transferred were specifically addressed in 1985, and consent was obtained therein. Section 5.2 of the DPDP explicitly recognizes consent for any past transfer of certain records, and Section 5.2 clearly states that consent is valid for that, which is why the Council is trying to say that the petitioners are alleging a retrospective application of the DPDP Act. In arguendo, even if we assume that the DPDP Act is going to apply to this scenario, the respondents fall under the exemption given under Section 3 of the Act. Section 3 of the Act states that Digital Personal Data Protection Act does not apply to personal data made publicly available by the data principal himself or caused to be made publicly available. Your Lordships, in this case, all of the recordings on which Nebula AI has been trained are commercially released recordings of Mr. Pandit Rudra that are out in the public. These are the recordings using which Nebula AI has been trained, and they fall into the publicly available exemption.
You made it publicly available.
Your Lordships, in this case, it was with the consent of Mr. Pandit Rudra that these songs were first initially released to the audience as sound recordings for them to hear as songs.
Which was made publicly available. It is...
Section 3 of the DPDP says it is publicly available data that is also caused to be made publicly available by the data principal himself. In this case, the data principal himself wanted the data to be publicly available. That is what Section 3 Clause C of the DPDP states. It states that publicly available data made publicly available by the data principal himself or caused to be made applicable by the data.
You were the publisher in that case.
Your Ladyship, by publicly available, I mean that these songs are now open to the public. I am not referring to the AI-generated music album.
No, I agree with you. The training data was clearly the recordings of Pandit Rudra. Correct? The system was trained using catalogs owned or licensed by Swargunj Digital, including Pandit Rudra's recordings. including Pandit Rudra's recordings licensed by Swargunj Digital. It clearly says that the training data was the catalogs that we were referring to.
Your ladyships, it is trained on the master recordings which is owned by Swargunj.
Yes.
Master recordings are nothing but the original finished recordings that are released to the public for them to hear as songs.
You cannot seek protection of the causality that you yourself have created. Your office has been the publisher of this material. Now that it is published, you're saying, I don't need to seek consent anymore because it is published.
Your ladyship, section 3 of the DPDP clearly states that even if that personal data, which is Mr. Pandit Rudra's songs, have been caused to be made publicly available by the respondents themselves, using those songs to now train the AI, the Nebula AI, which we are now under collaboration with, also falls under the exemption given under section 3.
That's not what section 3 explicitly says at all. Let's be clear. Section 3 doesn't explicitly say any of that. Section 3, clause C is about the non-applicability of DPDPA. It says C2 says personal data that is made or caused to be made available by the data principal to whom such personal data relates, or any other person who is under any obligation for the time being enforced to make such personal data publicly available. The objective of the Act cannot possibly be to misuse this provision, in which case, if I have, as the fiduciary of your data, I get to just publish it and say, hey, guess what? It is now published. It's no longer personal data.
Example, an individual, while logging their uses, publicly made available or personal data, in such cases, provisions of this Act shall not apply.
So the argument that they are making is, once X has published their data, then this is no longer public. But here I'm saying that they are the ones who have enabled X to publish their data. They are the publisher.
In the first instance. At the first instance. Yes. Okay, I think you can proceed.
Your ladyship, to answer your question, the argument that the respondents are trying to make here is that these recordings were made publicly available with the consent of the petitioners when they were licensed to us to release it in the public forum. It is these recordings that are now available in the public forum that are used to train the Nebula AI. In arguendo, even if we assume that the Section 3 exemption does not apply, the respondents categorically fall under Section 7A of the DPDP Act. Section 4
what
of...
you mean to say is that it is already in the public domain, it is no more personal data. That's what.
That is the primary submission.
Therefore this Act is not applicable.
Yes, that is the primary submission.
Yes,
The
yes.
secondary
Okay,
submission.
yes.
The secondary submission is that even if in arguendo, we do assume that Section 3 exemption does not apply to the respondents in this case. Section 4 of the DPDP Act makes it clear that there are two lawful bases of processing. One being consent as defined and the procedural formalities under Section 6 of the Act, and another being legitimate uses as defined under Section 7 of the Act. Section 6 of the Act requires for explicit consent along with procedural formalities of it being informed, notice being given, it should not be unambiguous, etc., etc. But Section 7 goes away from all of these formalities if the data processing activity falls specifically under any of the clauses enumerated under Section 7. Here, the respondents contend that the activities carried out by the respondents fall explicitly under Section 7A of the DPDP Act. Section 7A of the DPDP Act clearly states that a data fiduciary, Section 7A of the DPDPA expressly permits a data fiduciary to process personal data of a data principal for the specified purpose for which the data principal has voluntarily provided her personal data to the data fiduciary, and in respect of which she has not indicated to the data fiduciary that she does not consent to the use of her personal data. There are two important things to be noted under this said Section 7A of the provision, Your Lordships. One being that the data principal has to voluntarily provide her personal data, which was voluntarily provided under the 1985 agreement, whereby the petitioners have shared all of their rights, title, and interest in the master recordings and the performances embodied therein. And two, this provision explicitly places the burden on the data principal to indicate any non-consent of the processing of such personal data. Within the lifetime of Mr. Pandit Rudra, not once has he challenged this clause to be problematic or not accepted by him. Therefore, the processing which has been taken place, if the argument does not fall for Section 3 or the complete inapplicability of the DPDP Act in itself, squarely falls under Section 7A of the DPDP Act. Here, Your Lordships, to further this argument, Section 7 of the DPDP Act was under a different nomenclature under the DPDP Bill of the 2022, and it was under the nomenclature of deemed consent. If I may read out that provision also, my lordships, the DPDP Bill authorized deemed consent for processing that was necessary where the data principal voluntarily provided personal data to the data fiduciary, and it was reasonably expected that she would provide so. Here, your lordships, the change is in the word reasonably expected. This word was explicitly removed from the DPDP bill, and it was replaced with specified purpose. By replacing it with specified purpose under Section 7A, a broader interpretation has been given to this subsection of Section 7. Because when we're looking at reasonably expects, we are putting a point of view objective from that of the data principal, whether or not that they would contemplate AI training where they gave their personal data. If that language was retained, then the petitioners might have a case to say that they did not contemplate AI generation. But to change from reasonably expect and to put the word specified purpose, it means that the reliance is now on the literal contextual interpretation that has been given under the 1985 contract in itself. And the specified purpose that the 1985 contract signed was to give all rights, title and interest to the respondents unequivocally for them to use it for AI training. Therefore, your lordships and ladyships, this processing by Swargunj for furthering their contractual rights that were given under the 1985 agreement squarely falls within Section 7A of the DPDPA.
The whole point of the execution or the contemplation of DPDPA was to enshrine rights to privacy. It's not like there was no passing of personal data before the DPDPA came into place. The whole argument was that contract terms were far too wide. While I agree with your interpretation, the term specified purpose means the purpose mentioned in the notice. I would argue that Clause 14B in its drafting would not pass muster in a DPDPA era. Clause 14B in its ambit seeks to give too much of an umbrella term of the passing of personal data from Pandit Rudra to Swargunj, in its current format. I would argue that the clause in itself stands to be challenged under the term specified purpose.
Your ladyship, the specified purpose in this case was to give us all of the rights. That was the original intent and the consensus ad idem of both the parties. Specified purpose need not necessarily mean only a particular purpose. It can be a colorful combustion of all of the purposes and all of the rights, title and interest as the petitioners have intended therein. And your ladyship, I would also like to take another argument in this case, which is that Section 5.2 of the DPDP makes it clear that any past consent where data has been obtained stands valid as long as any other obligations that are to be fulfilled by the data fiduciary are fulfilled. Here, it is important to note that under Section 5.2, there is a right to withdraw given to the data principal if they do not want such processing that they had given consent to before the DPDP Act came into force to now follow through. In this case, unfortunately, Mr. Pandit Rudra had passed away in 2023. And to somehow understand that this right of withdrawal or to challenge under DPDP could posthumously go on to his legal heirs, Ms. Tara Rudra or the Rudra Heritage Foundation, would go against the simple language of right to privacy. Right to privacy is a right in personam, and a right in personam dies with the death of the person. Your ladyship, here comes the play of the maxim, actio personalis moritur cum persona, which says a personal right of action dies with the person, preventing third parties from exercising or purporting to enforce the rights of deceased individuals. To assume that in any case where a company or startups or operations running on consent derived prior to the DPDP Act have to cease operations immediately because third parties now claim that this consent is not valid solely based on their own exercise of mind would prove to be such a bad precedent and create such an operational burden on all of the companies who are acting on consent of data that was given prior to the DPDP Act. The DPDP Act also gives the right to nomination under Section 14, which was not exercised by Mr. Rudra in this case, and therefore there is no nominee who can also claim a right of...
Yeah, I'll just ask you the same question that I asked your fellow counsel, but didn't get an answer. And one of the arguments raised by the petitioners is that BNS 356 and the Berne Convention, Article 6, protects post-death as well. So do you, in the light of these international conventions and other things, don't you think they have a very valid argument?
I am not able
Yeah.
to hear you. If you could just be a little louder.
No, I said, I don't know if you heard the arguments of the other side, but they had argued that, BNS 356 and the Berne Convention, etc., protect certain rights that are there post-death as well. So I was wondering if you had, how would you respond to that argument in the light of what you're saying?
Your Ladyships, the rights that the petitioners have contended extend posthumously stem from Article 21 and from Puttaswamy to many judgments hereinafter. All of these rights are rights claimed in personam. And a right claimed in personam dies with the death of the person. And unless somebody is explicitly nominated, as given under the DPDP Act, a third party cannot posthumously come and exercise these rights on behalf of such person, because that would lead to a lot of cases flooding the Supreme Court doors, where people are coming with the intention that a person who is now dead would not have consented to the same. If the Supreme Court provides such a precedent where a third party who is completely unauthorized to file a case before the Supreme Court is allowed to come and claim rights on behalf of a person who is deceased, that would create a huge operational burden on all of the companies operating in this country.
I think that principles you are misapplying it. Actio personalis moritur cum persona. It is an action or the act dies with the person, not the right. How did you translate it as a right?
Your Lordships, what I read was a personal right of an action dies with the person. Meaning,
a personal act it is, not
indeed,
a
the
right.
to withdraw by
A
mistake.
right, it all depends when either it is a contractual right or a statutory right. It is as per the statute or as per the contract, terms of the contract, it follows. It is always heritable or alienable as per the subject matter of the contract. So I think that...
As your Lordships is also stating,
yes.
and as what the Council is also trying to argue, is that a personal right of action here in the DPDP context is the right of withdrawal. This right of withdrawal has died with Mr. Rudra in the absence of him nominating anybody to exercise his rights on his behalf. To accept a claim on behalf of Rudra Heritage Foundation or Ms. Tara Rudra, for them to come and claim DPDP violations would create a precedent whereby unauthorized people are claiming rights based on pure assumptions on behalf of deceased persons, thereby complicating operations of businesses and other companies that are operating on consent and data that have been obtained prior to DPDP.
That means he has not asserted his right during his lifetime, so his nominees or successors cannot assert that.
Because he has not explicitly nominated anyone, and in this case, the right that has to be asserted is also a personal right.
Right, okay. That's
But then what is the foundation for?
The foundation for it is the DPDP Act in itself.
No. My point is the Rudra Heritage Foundation was established for the preservation of his artistic legacy and administration of his residual interests. Are you saying that so let's take it from a commercial perspective. If an individual, an artist passes away, then if the rights do not pass on to the heir, are you saying that a production house can then continue to exploit the material without having to make any commercial dues to the estate of the deceased singer?
As long as it is within the contractual limits, my lady. That is what the Council is trying to argue. Here, primarily, whatever has been done by the respondents is within the contractual limits. Secondly, the petitioners are claiming that this is allegedly not within the contractual limits without being explicitly nominated by Mr. Rudra to come and claim
The DPDPA was not in force at the point of his death.
Indeed, your Ladyships, that is simply what the Council is trying to put. If the DPDPA was not in force at that point when Mr. Pandit Rudra was alive, obviously he did not get the right to nominate anybody. But now, if we understand that Ms. Tara Rudra or the Rudra Heritage Foundation can come and place a violation of right under DPDPA, it would mean that this court will ultimately set a precedent whereby anybody or any company that is operating on data that was obtained prior to the enforcement of DPDPA given by the consent of a data principal who is not alive anymore, any third party can conspicuously try and manipulate the intent and come and claim that that person, if they were alive today, would not claim these rights to be void. If that precedent is set by such a court, the business operations of many companies and many people and establishments in this country would come to a standstill, because that kind of precedent is not what the DPDPA ever envisaged. And since they never had the right to fight...
You can pass on to the next
Indeed.
issue.
I would just like to
Only
conclude.
4 minutes are there.
Continue to the next issue.
I would just conclude this issue and move on to the next issue. Considering that there is no there is no locus standi with
this
respect.
issue is enough, don't worry. Go to next 2 minutes.
Indeed, Your Lordships. The final issue that the Council number 2 will be dealing with is whether the constitutional guarantees of dignity impose limits on contractual commodification of identity attributes in technologically unforeseen contexts. Your Lordships,
See, what is the legal basis for this contractual commodities? Where do you get it? Where is the legal provision governing this? Contractual commodities, no?
your
In
Lordships,
expression, where do you get this legal, under which law, under which act? Where
Your
can
Lord-
we trace its...
Your Lordships, a contract finds its essentials and validity within the Contract Act in itself. As long as there is offer, acceptance, consideration, consensus ad idem, and a lawful
Okay,
object of contract.
this is related to, in the contract, this is related to what concept?
This is related to the contract in itself, which granted Swargunsh all of the master recordings and the performances embodied therein. The petitioners are claiming that, if I could seek an extension of merely 2 minutes to summarize this issue.
Yes.
The petitioners here are claiming that by way of the rights granted under the 1985 agreement, there has been commercial commodification, which ultimately violates the right to dignity of Mr. Rudra. The Council would like to first submit that the right to dignity encompasses a lot of rights within it, with bare sustenance, physical dignity, etc., etc. But here, the right to dignity violation that has been claimed by the petitioner.
No, dignity is quite, I don't think it is involved in this. It is commodification.
Indeed, if I may read the
Commodification
issue,
of the right.
whether constitutional guarantees of dignity impose limits on contractual commodification of identity attributes,
Dignity.
technologically unforeseen
Dignity imposes limits on contractual commodification. Yes, yes. What do you understand by that issue?
What the petitioners are trying to argue is that Article 21 dignity imposes a limit on what a contract could legally transfer. Here the petitioners are claiming that by having rights assigned over the master recordings and the performances embodied therein, the respondents have caused some kind of defamation or reputation harm to the artistic identity of Mr. Rudra himself. But here, to claim that artistic identity has violated Mr. Rudra's right to dignity through commercial commodification does not stand merely because what is produced by the AI has nothing to do with Mr. Rudra's way of singing or his songs. What is produced by the AI is completely different. If you may refer to the Moot proposition, it says what is produced by the AI is electronic music styles which are completely different from what Mr. Rudra sang. And the AI is not only trained on Mr. Pandit Rudra's recordings, it is trained on a lot of number of artists' recordings. So what is ultimately...
I think that has already been explained, I think, what has been.
Indeed, Your
I think,
Lordship, since
yes.
the issues are connected, the Council would simply have to rely on the previously stated facts. That is what the Council is trying to put forth.
Yes.
If I could just conclude my argument
Yes,
on
yes,
this
sure.
under
Yes.
30 seconds.
Okay.
Since there has been no reputational or impunity that has been given to the artistic identity of the respondent, of the petitioner in this case, a dignity claim cannot even lie. Furthermore, dignity under Article 21 protects human autonomy, not property interest post-assignment, rendering claims over alienated assets incoherent as dignity rights cannot be asserted over what is no longer owned. In this case, the petitioners have unequivocally given us all rights, title and interest to the master recordings and performances embodied therein. And in consonance with the Raj Rewal case, we have balanced the right to dignity along with our right over the assignment given to us to do what we were able to do within the assignment, that is to create an AI-generated music album, the consent to which was obtained under the 1985 agreement in itself. If the bench is satisfied with the submissions, the Council would move on to the prayer of the case.
Yes.
Much obliged. Therefore, in the lights of the facts stated, issues raised, arguments advanced, and authorities cited, it is humbly prayed that this Honorable Supreme Court may be pleased to adjudge and declare, dismiss this petition placed before the Honorable Supreme Court, personality and dignity rights protected under Article 21, extinguishes with the death of a person and do not limit commercial exploitation through AI systems. An AI platform generating expressive outputs functions as an intermediary entitled to safe harbor protection, A contractual assignment covering technologies now known or hereinafter devised includes generative artificial intelligence capable of producing synthetic performances resembling an artist's voice. Machine learning training using commercially released recordings does not constitute processing of personal data under the Digital Personal Data Protection Act, and constitutional guarantees of dignity do not impose limits on contractual commodification of identity attributes in technologically unforeseen contexts. This Honorable Supreme Court may pass any other order as it deems fit and proper in the interest of justice, equity, and good conscience. And for this act of kindness, the respondent shall duty bound forever pray. It was an honor arguing before this bench. Thank you.
Thank you.
To address the bench.
Yes.
Much obliged, Your Lordships.
Rebuttal is there. Yes.
Certainly, Your Lordships. Your Lordships, firstly, the Council here would like to declare that the Honourable Bench in their infinite wisdom have already covered a vast majority of the petitioners' rebuttal points. However, the petitioners, the Council for the petitioners would like to propose certain rebuttals. Firstly, Your Lordships, my learned opposing counsel cannot simultaneously tell the market that this is Rudra's voice and then also tell this Honourable Court that this is only statistical output that is anonymous. Your Lordships, the mere fact that vocal attributes have been used that are identifiable to Rudra as an individual is very clearly going very against the DPDPA Act. Your Lordship, relying on the very definition of personal data under the DPDPA, under Section 2, Clause T. Moreover, Your Lordship, my learned opposing counsel has very conveniently contended here that the data was made publicly available. The data that had been used to train Project Awas was publicly available data. Your Lordship, the Council would like to bring to the attention of this Honourable Bench the very words of the factual matrix that have stated within para 4 itself, mentioning the development of Project Awas, that the collaboration, the system was trained using catalogs owned or licensed by Swargunj Digital itself. Your Lordships, nowhere is it contended that public data was utilized within the training itself. Therefore, the Council for the petitioner would like to contend that this is a clear manipulation of the facts to support their arguments, Your Lordships. Your Lordships, furthermore, the respondents have very conveniently acknowledged that moral rights do exist and can be exercised. However, Your Lordships, they have also stated that since there was no distortion, they are not applicable within this present case. Your Lordship, the Council would again like the Honourable Bench to refer to the proposition itself within the factual matrix, para 5, release of Rudra Reborn. Your Lordships, it has been held within this that it has distorted his identity and philosophy. The users pertaining to the deepfake incident, Your Lordships, the public response was divided, and the incident, the repercussions of the very incident distorted his very identity, and therefore the Council would like certain clarification within that. Furthermore, Your Lordships, the Council has also contended that the data becomes public after the death of the individual. The Council requires clarification on where the learned opposing counsel is basing these very broad claims from. And moreover, lastly, Your Lordships, the Council has very conveniently omitted the non-compliance with the due diligence guidelines as prescribed under the IT rules and the IT Act. The Council would like to substantiate this within the Grok notice itself. Pertaining to that very notice, the Council seeks certain clarification and the respondents' arguments, Your Lordships. That is all, Your Lordships. The Council rests. It was a pleasure arguing before this Honourable Bench. Much obliged, Your Lordships.
Greetings to the bench. The Council would like to address all of the rebuttals that have been raised by the petitioners in this case. Starting with, Your Lordships, the facts of the case is of such nature that once Mr. Rudra's voice has been put into this AI, within the neural network, all of these vocal attributes gets transferred into statistical parameters. So when this...
I've already argued, but again rebuttal why? Already you have submitted the same point.
Your Lordships, it is because that it has been raised by the petitioners in this
That
rebuttal.
doesn't mean that, yes. Okay, nothing new to add to that. Yes.
Indeed, Your Lordships, what the Council was trying to put here is that once it comes within the neural network, it becomes statistical parameters. And what is also produced is not a replication of the stored recordings. It is merely an AI-generated music album that has nothing to do with any of the artist's data that has been collected to train this AI. So even within the training process and even the output that has been produced by the AI has nothing to do with Mr. Pandit Rudra himself. Secondly, the council has tried to state that it is publicly available data is because all of these commercial recordings based on which this training has been done are publicly available songs of Mr. Pandit Rudra, which have been licensed to Nebula AI, which has been licensed to Swargunj Digital, because Swargunj Digital is a music composition company that makes these songs available on Spotify, Apple Music, for an example instance. And it is these songs that are publicly available in the public forum that have been used for training the Nebula AI for creating its function of creating an AI-generated album. And your lordships and ladyship, when it comes to distorted identity, it was merely an opinion that was stated in the facts. It is not a fact that can't be contended. What the fact states is that there have been sections of the public that have understood this to be distorting identity. But that comes with the fact that when any kind of artistic composition is released into the public forum, there will obviously be praise as well as criticism to that kind of an AI-generated album or music. But it does not mean whatever the output is producing is directly implicating Mr. Pandit Rudra's identity. And even section 57's explanation 1 states that just because an artist does not like the way the music is being represented does not mean that he has a claim for moral rights under section 57. And your ladyship, the due diligence guidelines came into effect from 10th February of 2026. And all of these acts and allegations and whatever has been placed before the respondents have curated under the year of 2025, and therefore as of today the 2026 guidelines do not apply to us, and even if they do not apply to us, we have taken the reasonable security measures on part of the respondents by including within the technical metadata that this is an AI generated album, thereby not misrepresenting or misidentifying Mr. Rudra or his legacy. With that, the council would like to rest their rebuttals in this case unless the bench has no further questions. Much obliged, your lordships. It was an honor.
Both parties have argued well. Reserved for orders. Yes.
May I please request the participants and members of the audience to proceed quietly and allow the judges some privacy to finalize the scores. If need be, the teams will be called back. At this point, I request all of you to please proceed to Academic Block 1 auditorium for the valedictory ceremony soon to conclude.